You are.
Okay, thank you, Aaron. All right, everybody, thanks for coming today. And I know I think there's a few people on digital also. So today we're going to talk about sexual harassment in the workplace, but it's going to be a different approach than y'all are used to. I'm just warning everybody up front. This is going to be a different approach because we pretty well know that the old approach of telling people a bunch of don'ts doesn't work. EEOC, we know that from EEOC because EEOC has been pushing employers to do sexual harassment training for 15 years, and they still have just as many sexual harassment charges filed as they ever did. So EEOC has concluded sexual harassment training, traditional type, doesn't work. I concluded that long ago, that traditional sexual harassment doesn't work, bunch of don'ts. So this is training designed for managers and supervisors, and we often have HR managers and vice presidents and others come in, so glad to have all of y'all here. To tell you a little bit about myself, I'm a labor employment attorney on the company side. I've been doing this for 36 years now. And back in the day, back in the 80s and early 90s, I was the chapter attorney for the West Tennessee chapter. All we did back then was traditional labor at ABC. We were fighting unions the whole time. I would get to work in the spring, fall, and summer at 6 in the morning every day. Can't even believe that, Joe. And the reason was because pickets came out around 6:15 or 6:30. So we had to be prepared for those phone calls. Those exciting days are gone because pretty much employees realize they don't really need unions anymore. And part of that was due to us labor attorneys. Part of it was due to organizations like ABC, which ABC is not a non-union group. It's a merit shop group. And believe it or not, did y'all know there are some union contractors that are members of ABC? There are around the country. So anyway, we all know that in the commercial sector in this part of the country, most of it has gone to merit shop contractors, which is a good thing. So, and to give you a little bit of background, which I think, Joe, you may know this, and to tell y'all a little bit about Joel and me, we used to play basketball together back in the day.
For a long time.
For a long time. And if I could catch him, I could block his shot, but he's a whole lot quicker than me, and so I usually couldn't catch him, so he was usually shooting over my head somewhere. Good shot. My own background is that I wasn't always a lawyer. I did a lot of different jobs, school teacher, etc. But one of the jobs I had, I was an unloader at Campbell 66. Who remembers Campbell 66? Raise your hand if you remember Campbell 66. This is pitiful. Y'all don't remember Campbell 66? National Trucking Company. National Trucking Company. And they had an unloading dock, a big one out on, I think it was Kansas Street or something. It's still there, it's just closed. They were a union company, and they had thousands of trucks driving all over the country. And you may remember, if any of you do remember Campbell 66, on the side was a picture of a galloping camel. Anybody remember that? Thousands of trucks. Oh, you got a little gray hair. You should remember that.
I should, but maybe vaguely, I don't know.
There you go. I'll take it vaguely. You remember what their slogan was? On every truck throughout the entire United States, above that galloping camel. Remember what it said? Humping to please. We can't do that one anymore.
I think I remember that one.
Every truck. Now, you remember it a little bit?
For a long time.
It's been a long time ago.
How long has it been?
Well, I was there in the mid-70s working on the loading dock.
I remember those now, Can't do that anymore.
Can't do that slogan anymore. So, which kind of leads us to what we're going to be talking about today, which is, and I think Aaron and I have been talking a little bit about maybe repeating the seminar, letting everybody know what's going on, maybe a couple times to give people the opportunity to do it. It's a great service that ABC is offering. We only have, I think, 2 supervisors here today, but it's going to be valuable for supervisors because this is training that all companies need to be doing, all y'all need to be doing for your supervisors and managers. And that will help prevent prevent sexual harassment charges and lawsuits. It will, it basically gives you points with EEOC and with juries and everything if you do this stuff. So it's a valuable service. I do a lot of this training. I think in the last 2017, I think I probably did it 30 or 40, 45 times maybe. Mostly regional, but other parts of the country too. Just finished doing about 8 or 10 sessions for Shelby County Schools for all of their their managers. They got thousands of them. So the training is important. It's important. We all know what's going on around the country right now. Did y'all see yesterday that, I forget the guy's name, I think it just happened yesterday, the president of Ford North America just stepped down? Rod something or other. Did you see that? I mean, this is brand new. It's like I saw it last night. And they haven't stated what it was, but it's pretty clear what it was. You know, you can read between the lines. So, I mean, it's literally everywhere. So, let's talk a little bit about it. And the way I like to do these things is y'all ask questions at any point you want, make comments. I like it to be interactive. So I don't fall asleep. You know, y'all keep me awake. I'll try and keep you awake. I don't think you're going to fall asleep in this presentation today. So we're going to talk about a couple of things. I want to start with my favorite 2 HR rules. You should jot these down. These are great rules. What's your name?
Tracy.
Tracy. These are great rules, Tracy. Here we go. Here's the first one, and it's one all of y'all's moms taught you. Count to 10. Is that not a great rule? Count to 10. Be slow to wrath, as the Bible says. Just count to 10. You know, when you're faced with an angry employee and you're trying to discipline or something, don't react. Don't get mad. I don't know if any of y'all have ever had an employee get mad at you. I know you 2 guys, I'm sure that's never happened because you both look like really nice, sweet guys. Well, it does happen, so count to 10. It's the best HR rule there is. Now I'm going to tell you the next best HR rule. This is a great one. There's so much stuff that happens in the EEO world, in the HR world, that people are just not prepared for. They don't know what to do. And sometimes when it's especially a big company, you got many different departments. You got a guy over here that, say it's an African-American employee, gets in a fist fight. You got a rule against fighting. So the supervisor says, well, we need to terminate him, violate the rule. Okay. What the supervisor over here doesn't know is that the HR manager knows, Tracy knows, because she knows what's in everybody's records, is that a 1.5 years ago, there was a white guy that got in a fist fight in the workplace and just got a 1-week suspension. Now, the supervisor may not know that because he only knows what's going on in his area. But the HR manager knows all of it, knows everything that's going on. So she knows, well, hold on. You know, the HR manager, her job is not to overturn y'all's decisions, believe it or not. It's to support the decision. But this is stuff you got to know. So on the surface, you fire the black guy for fighting in violation of company rule. A white guy gets a 1-week suspension for violating the same rule. It looks on the surface like if you're black, you get fired. If you're white, you just get a suspension. Now, maybe there's more facts, and Tracy knows. She can look at the file and say, well, okay, let's see if there's anything different. In the current case, the witnesses say, there's witness in the file that says the black guy threw the first punch. She looks at the file for the situation with the white guy in the fight a 1.5 years ago. Turns out the witnesses then say he didn't start the fight. Now, he reacted, he hit back. And that violates the no-fight rule, right? When you hit back. But it's not quite the same as starting the fight. So, does it make sense that maybe the white guy a 1.5 years ago would only get a 1-week suspension? The black guy gets terminated, but there's different facts. Does that make sense? I mean, and that's something that Tracy, as the HR manager, knows because she has all the files. But the manager might not go it, might not realize it. He might be ticked off at, you know, maybe he doesn't get to terminate that time. Maybe that's not the best thing to do. But Tracy has prevented a charge or a lawsuit. Save the company $1 million. Now, Tracy, I'm sure you know the rule, that when you as an HR manager save the company $1 million from some future lawsuit, you get 10% of those savings up front.
Always. In my 20 years, I've always gotten 10%.
Got that 100,000.
My outside company.
These guys are going into HR like tomorrow. So the second rule is pass the buck. If you're not sure what to do, if you got that fight, you want to turn, pass the buck. Bring in HR. In fact, this rule is so important, we're all going to say it together on the count of 3. 1, 2, 3. Pass the buck. Is that a good rule, guys? Call in and talk to your HR people. They're there to support you, and they have all the records. Okay, so here's what we're going to start with. Who's that guy? I'll recognize him, don't you?
Yeah.
Who is it?
Weinstein, is it?
Yeah, it's Harvey. Harvey Weinstein. Weinstein, I'm not sure which.
Yeah.
He's the guy that, you know, the classic Hollywood casting couch.
Mm-hmm.
Supposedly, I think he's got over 60 or 70 complaints against him now, sexual harassment, rape. All of the above. I mean, everything. Harvey did it all. But we all owe Harvey a debt of gratitude. We should all send him Christmas cards. Because if it wasn't for him, all these people wouldn't have come out. All the victims are now coming forward, and maybe we can finally deal with this problem of sexual harassment. Thanks to guys like Harvey. Because people are speaking out where they didn't before. Now, you know what I've heard sometimes is people say, well, look, those ladies went to Hollywood. They knew what was going to happen. So how can you call it sexual harassment and assault? And you know, the reality is that Hollywood casting couch has been going on for like 80 years in Hollywood. We all know that. So the young girl off the farm in Iowa goes to Hollywood to make it big, to become a big star. She probably knows there's going to be something like that happening. Hollywood casting couch. So I guess what we're saying is that if you know what you're getting into, then it's okay for someone to rape you. Is that what we're saying? Is rape okay because these ladies might have known there was going to be a casting couch? You believe that? You know, a lot of people think consent is a defense to sexual harassment. Now listen to this. It ain't. Consent is not a defense. Consent is not a defense to rape. Rapists sometimes argue, she went along with it, she enjoyed it, all that stuff. She didn't have any choice. Consent is not a defense to rape. Consent is not a defense to sexual harassment. What Harvey did is not okay. And the fact that it's been going on for 8 years doesn't mean it's okay to sexually harass females trying to get in movies, assault and murder. We all agree on that. But the main point here I want to get across is that consent is not a defense to sexual harassment cases. You know, the first thing I hear, and I've handled 400 to 500, maybe more, sexual harassment lawsuits, charges, investigations over the years. And I see some common patterns over and over and over. The first thing I'm going to hear from the accused supervisor or manager is, well, she laughed at the jokes. In other words, she's saying consent is a defense to sexual harassment. I'm telling you, consent is not a defense to sexual harassment, ever. Did she laugh at the jokes? Maybe. Why did she laugh? Maybe she laughed at the dirty jokes because it was a sexually oppressive environment. She knew she would never succeed at that company if she didn't go along with it, but she found it unwelcome. That's the key, not consent. That's not an issue in sexual harassment cases. Whether the conduct is unwelcome is the key. And that's a very subjective thing. Very hard to disprove a victim who says that the conduct in question was not welcome to her. Is that making sense to y'all? Yep. Okay. So that's Harvey. Now I want to show you I'm going to show you a couple of clips. These clips are, it's an HR professional, Mark, he's got a blue shirt on in the video. Now these guys are not actually HR people, they're lawyers in our firm around the country. And they're playing these parts. So I just want you to know what you're seeing. But what you're going to see is stuff that they're not doing right. You're probably especially going to get taken care of when you see some of this stuff. But I've always thought the best way to learn this stuff is to see the wrong way. So this is a bunch of wrong stuff. So just when you see something that you know is wrong, you think is wrong, just holler out or nod or something or roll your eyes or something. But the basic setup is that Mark's sitting there at his desk, the HR professional, and Ernest comes in to Mark to complain that he has observed sexual harassment, that he has observed another employee, John, sexually harassing Jerry. Okay? So, and he's nervous, he gets confused about who's harassing who, but kind of see if you can pick up the things that Mark is doing wrong, and then we'll talk about them afterwards. So, let's see if this works. Hopefully it will.
Ernest, what's going on? You just caught me before lunch. I was actually just heading out. What's happening?
Oh, good. I'm glad I caught you. Mark, there's a couple things I want to talk to you about. The first one's a little uncomfortable, but I need to share it with you. I have a complaint of sexual harassment.
Ooh. You got anything in writing?
No. This is...
Are you prepared to put anything in writing?
Mark, we've been friends a long time. This is just one friend to another. I just need to share this with you. I'm not putting anything in writing. I don't want to get anybody in trouble. Maybe this is a bad idea. I should just keep my mouth shut.
Stop. Sit down. You're not going anywhere.
You tell me I can't leave?
Hell no, you can't leave. We're going to get through this. Well, tell me what's happening. Look, if you want to have an off-the-record discussion about this, then go ahead. What's happening?
Well, it's Jerry. He acts in ways I think that are inappropriate towards John.
All right, stop. Now look, don't report anything serious unless you've got good reason to do that, because oftentimes people get fired over this.
You're saying I'm going to get fired?
As I sit here right now, I have no reason to know if you're going to be fired or not. I'm not aware of anything, but I'm just warning you. These kind of allegations get people fired. Go ahead. What's happening?
I don't want to get anybody fired. I don't want to get anybody in trouble. But here's what's going on. I'm convinced that John is harassing Jerry. He calls him honey, which is kind of weird. I don't know if he's joking or not. He's very touchy, kind of huggy. I certainly would feel uncomfortable if a coworker treated me like that.
Well, what else? I mean, have you seen, is there any kind of correspondence or anything else you can point to?
Well, I have observed. I've observed John's emails to Jerry, and they're just weird. They're very odd. They're very personal. Lots of innuendo.
I guess I should take better notes. Look, this was an off-the-record discussion, so keep it to yourself. Obviously I'm an HR professional, so I'll deal with it accordingly. But right now, just keep it to yourself, okay?
All right. Well, I won't tell a soul, and I hope you don't tell anybody either.
Yeah. Anything else?
Yeah. One other thing, and this just relates to me personally. I've been very stressed.
Stressed?
Yeah.
Stress from what?
Well, my job's very stressful.
Stress from your job's causing you stress?
It really is.
You know what they call a job without stress?
What do they call a job without stress?
A hobby.
When you're joking, this is funny to you?
No, but I mean, come on. We're all stressed about work.
Well, this is a doctor's note. I've got a doctor's note.
Did you give this to your supervisor? What is this?
No, it's the doctor's recommendation that I get 15 minutes of rest for every hour of work.
15 minutes for every hour you work?
Yes, it's to help me deal with the stress so I can calm down.
Look, I don't see the company being able to accommodate that. I asked you if you've given this to your supervisor. Have you talked with him about this first?
No, I haven't.
Well, look, there's a chain of command here. Don't bring this to me. Give that to your supervisor, and we'll go from there.
Well, okay, I'll give it to him. Now, I got this new iPhone app to help me keep track of my hours worked, and this is hours worked, right? I'm going to go take my lunch right now.
This discussion about office gossip is hours work? No, this is your lunch break.
Oh, this is my lunch break? Okay, well, I'll make sure I
We talked office gossip and your request to get a break for every hour. Of course, this isn't hours work.
All right, well, thanks for your time, Mark.
Yeah, you're welcome. I'm buying time.
Tracy, is that the way you would have handled it? I saw your eyes get kind of big about half a dozen times in there. So let's talk about this a little bit. So Ernest is complaining to Mark, and he's making a sexual harassment complaint. He's observed John, he thinks sexually harassing Jerry. So the first thing Mark does is he says, well, I gotta have something to write. Is that true? Yeah. I mean, sexual harassment complaints don't count unless they're in writing? No. Tracy will tell you that what you observe, and if you observe sexual harassment, you got to deal with it. It doesn't matter whether or not there's a written complaint or even any complaint. If you're aware of it, you got to deal with it. Then he says to Ernest, you can't leave. What would we call that? You might know state law. Ever false imprisonment? Yeah. You can't force. I mean, you like the guy to stay, but you can't force him to stay. And then he says, "Oh, this is great. I saw you jump up on this." That he tells Ernest, "You can be fired for complaining." What do we call that? The law. Retaliation. It's illegal. You can't be fired for complaining about the protected group discrimination. And Mark says it's off the record. Is there any such thing as off the record? Not a chance. And then Ernest shifts gears and he's stressed. He's got a doctor's note. He needs 15 minutes off every hour of work. Now, okay, that's a little bit much. But what does Mark do? He doesn't even pay any attention to it. He tosses the paper back. We're supposed to, if the guy has a disability, we don't know if he does or not yet, but Mark should be figuring out if there's some other accommodation that might be reasonable to help relieve some of the stress. So Mark just disses the whole thing. And then the last thing that Mark does is Ernest gets out his little app and he figures he's getting paid for this time. And Mark says, no, this is your lunch time. You can't come in here and talk gossip with me and expect to be paid for it. So is that what we're going to do to employees? We're going to punish them for complaining by taking their pay away? That's retaliation again right there. So Mark is...
They call it gossip.
They called it gossip, yes. Called it gossip. Oh my goodness. Okay, now let's follow up. Now Mark, the HR professional, is going to confront the accused harasser, John. So let's see how maybe he'll do better on this. What do you think?
John, thanks for coming in. Look, we got an issue. I wanted to talk to you about it privately. I wanted to talk to you without any witnesses present. We got something going on.
What's going on, Mark?
Look, I got an off-the-record complaint from Ernest that you've been harassing Jerry again.
Are you kidding me? Ernest saying it harassed Jerry? You mean sexual harassment?
Yeah, well, look, like I said, it's an off-the-record complaint. I can't get into details, but yeah, that's the gist of it.
Just so I'm clear on this, Ernest complained that I was harassing Jerry. He's not complaining I harassed
You heard what I
him,
said,
right?
That's right. So let me ask you, are you asking Jerry out? Are you hitting on him? Trying to come on to him?
No, no, and no, Mark. Outrageous.
Why would he make something like this up?
Probably a whole lot of different reasons, but
Tell me one. Tell me one good one.
One reason for sure. I mean, he's jealous. He's jealous of the relationship I have with Jerry. We're friends outside of work. He doesn't have that relationship with me. He doesn't have that relationship with Jerry. I mean, we're all on each other's Facebook, so he knows Jerry and I communicate.
Look, I don't do Facebook. I'm not on Facebook. How would I check any of this out?
Well, as long as you have a password, you can get on.
Give me your password. I'm going to go on. I'll check this out.
I'll give you my password with one caveat. You can't say anything that I wouldn't say if you're using my password.
John, I'm an HR professional. I wouldn't do that.
Okay.
All right, let me ask you. Have you ever sent Jerry a personal email from the company computer?
Absolutely not. All of my company emails I send to Jerry have been business in nature, Mark.
That's disappointing, John.
Excuse me?
Look, I'm going to tell you. I've checked the computer, and there's a whole lot of personal emails from you to Jerry.
By meaning you check the computer, does that mean that you had someone go in and go into my password-protected Yahoo account to look at my emails?
Let me spell out for you. Yeah, I went in, I read the emails that you generated and sent from the company computer.
Absolute invasion of privacy. I'm disappointed in you, Mark. I'm disappointed in the company.
Take it up with our outside attorneys. I got a 3-page memo on fancy letterhead that says I can do it. You can read it. Look, other than, I'm going to check out this Facebook stuff. Other than that, is there any other reason why you think you'd be making this up?
Oh, yeah, another reason. He knows he's on the brink of getting fired.
What are you talking about?
Well, I'll tell you, and I'll give you an example. Today, he showed up. He was 10 minutes late. Last week, he was late 5 minutes one day, and he was late 7 minutes the other day. I mean, you gotta be at this job. You gotta be at your desk at 8 o'clock. It's unbelievable. This stuff's been going on for a long time, but it's really, really hit a flashpoint in the last couple of weeks. And he knows it.
Stop. I haven't had a chance to look at his personnel file before we had an opportunity to meet. Have you been getting HR involved in this? I haven't heard anything about this.
I'm a manager, Mark. That's what I do. I coach my employees. And obviously it hasn't worked with Ernest.
No, it hasn't.
It's time for him to go. Got and telling lies about me.
I'm going to tell you, John, this isn't looking real good for you. I got these allegations. I got unreported issues of performance or misconduct or whatnot. Look.
Well, let me tell you something, Mark. I'm not too happy myself. And it's this, the way the company's handled this investigation. But I'll give you an example of the way I've been treated around here. I just got back from reserve duty. Been treated poorly by you, by other managements. Last year I got back from reserve duty. Same thing. I got put on the bad schedule for 6 months after I got back. It's unbelievable.
Let me be very clear. You could be terminated today for failing to disclose your reserve duty military status to us during the interview process. We specifically asked you about scheduling issues, and you said you could do it. So don't bring that up.
Okay. Now, if I'm not suspended, Mark, I want to go vindicate my name because Ernest, I'm going after Ernest for telling lies about me. I need to vindicate my name.
No, you're not. Listen to me. You're not going to do anything. And if you do, you will be fired. You're not to talk to a single witness about this unless you think they're a critical witness and they got something important to say. Otherwise, don't talk to them. If you do, John, you will be fired.
Are we done?
We're done.
Okay. Did you see any problems there, Tracy? I think Mark needs to be fired. But, so let's go through these. So first of all, Mark tells John, well, first of all, there's no witnesses. You always got to have a witness in there. What if the other person tells a story on it? Next, Mark tells John the name of the person who complained. Tells him Ernest complained. That is like rule number one. You can't tell the name of because what John is going to do is now go after Ernest. He said so. He said, I'm going to go after him. That's retaliation that Mark is responsible for causing. So what else did he do? Well, he talks about hey man, how you doing?
How are you?
We got a Lincoln guy here.
Yeah, sorry for the interruption.
So the next thing that happens is we got Mark saying he can justify going on this employee's Facebook account, looking at the password protecting it. He's got a lawyer's letter that justifies it, right? Now, let me tell you something. Don't raise your hand. This is a rhetorical question. Have any of you ever had lawyers of your own? Probably all of you. You know why you pay $3? And by the way, you should always pay more. Oh, right? But why you pay $3 for lawyers? In case you get something called the attorney-client privilege. Anything you talk to that lawyer about, you don't have to testify about that later because it's privileged. The lawyer can't talk to about it, and you don't have to talk about it. It's a privileged conversation. That's the most valuable thing you get out of a relationship with a lawyer, is that privilege. But you can waive that privilege unintentionally, and that's what Mark just did in the video. He told John what the lawyer told him, and then he offered to show him the lawyer's letter. He just waived the privilege. Not only did he waive it as to himself, a manager, he waived it for the whole company. That's what you got to keep in mind as managers. You have that ability to waive the attorney-client privilege on behalf of your employer. That right there, Tracy, I think would justify your termination of Mark. So then what else? What about the password protected account? You think he had the right to go into that? That one's pretty fuzzy, but you know, this is a developing case law area, but whatever, he didn't do it right. And there should have been policies in place that would have allowed access, but still, it's the guy's personal Yahoo account, probably not a good idea to be going into that. And then the very last thing is Mark says you can be fired because you didn't disclose your reserve duty to us. There's a statute called USERA, which protects reservists. want reserves to protect. They're out there fighting fights for us. So you can't retaliate against reservists for reserve duty. So, Mark, Tracy, you would have fired him on the first video, I think. All right, so that's a lead in. That tells you how the stuff to do that you shouldn't be doing, which I think is a great way to learn. Now we're going to talk about home discrimination, harassment, retaliation. We've talked about it a little bit already. I think it's important to understand what discrimination is, what the laws are. I'm just going to talk about the laws for just a minute because I don't like talking about it. I think it's kind of dull. But let's talk about it. We got a couple of laws we got to talk about. First one is Title VII. That's the 1964 Civil Rights Act. Bars discrimination in the workplace based on 5 protected workplace topics. What are they? Race, religion, what? Sex or gender. 2 more. National origin. It's 4. 1 more. Don't worry, this is one nobody ever gets. It's not a phase, there is its own statute. It's not disability, there is its own statute. Color. Color is the 5th protected group. Now,
Race?
well, nobody knows. But it probably connected to race, could be connected to national origin. But what the courts mostly say is that, and this is rare, we probably never had a color discrimination charge. I had 4 or 5 over 36 years, so it's just not common at all. But I think it's important to know what it is. Color discrimination typically is when a dark-skinned African-American employee alleges discrimination by his light-skinned African-American supervisor. So you'll probably never have one of those, but if you do, it's good to know what it is. So Title VII is our main workplace law, and then I also mentioned there's other federal statutes out there that are applicable to the workplace as far as employment matters, such as the Americans with Disabilities Act, the Fair Labor Standards Act, the Family Medical Leave Act. What did I leave out? Age Discrimination in Employment Act. Lots and lots of federal statutes protecting employees. We also have the same at the state level in most states. In Tennessee, for example, we have the Tennessee Human Rights Act. The Tennessee Human Rights Act basically does the same thing as Title VII and ADA and all these other statutes. Tennessee has its own Handicap Discrimination Act, has its own Leave Act, it protects leave for pregnant females, and of course in Tennessee you have the Tennessee Poor Performance Protection Statute, which bars an employer from firing an employee simply because the employee does a lousy job.
Say that again, Jim.
What's that?
Said the last thing you said again.
About the Tennessee Poor Performance Protection Statute? All right, you got me. There's not really a Tennessee Poor Performance Protection Statute. Just want to make sure you were listening. You were. But there are all these other statutes, in Tennessee, and most states have their own fair employment practice statutes like Tennessee. Now, Mississippi does not. They don't have a state version. So in Mississippi, if an employee wants to file a charge, he can't, like in Tennessee, go to the Tennessee Human Rights Commission. He can only go to the federal agency, EEOC. Anybody here from Mississippi? Anybody from Mississippi? Nobody? Come on, come out of the closet. Nobody from Mississippi? Well, Mississippi is an interesting state. Sometimes I make jokes about Mississippi, but I grew up 6 miles from Mississippi, and I like Mississippi. You ever been to Mississippi? In high school, at East High in the mid-'60s, go Mustangs, when I was 18, I couldn't buy beer in Tennessee because you had to be 20. But I could slide over the border in Mississippi and I could buy my 6-pack. So I like Mississippi. The only thing I don't like about that is that when we went down there, me and my 18-year-old buddies and bought beer, all that beer in Mississippi is 3.2. It was. In Tennessee, it's 6.4. So I could get the beer in Mississippi, but I had to buy twice as much. So I like Mississippi, but I'm still a little irritated about it. Anyway, just bear in mind, Mississippi is not like America. It's a little bit different. And one of the ways it's different is they don't have their own state employment practices statute. So they only have EEOC there in the federal statutes in Mississippi. Probably an important thing to keep in mind. If you have employees, I know you both have jobs in Mississippi from time to time. Your employees who are working in Mississippi can file charges at EEOC in Jackson, Mississippi, at the Jackson EEOC. If they're working here, it's wherever you work, basically, that the employees can file their charges. All right, so having said that, let's talk about basically two concepts under discrimination. We're working our way towards sexual harassment, but harassment is part of discrimination, so I want to talk about that a second. Discrimination basically means this. It means the employee says, I was treated differently because of my blank. Wherever the blank is the protected groups. Race, gender, disability, age, whatever it is. I was treated differently because of my race, my gender, etc. That's typical employment discrimination cases and charges. You guys have both seen those kinds of cases. You have two races. It's different treatment. They're called treatment cases for short. Now, let me ask you all a question. Is harassment illegal?
Yeah.
Who thinks harassment is illegal? Raise your hand. Anybody else?
I would think so.
Is hostile work environment illegal?
I would think so.
You guys gotta learn something. I'm a lawyer. That means I ask trick questions. Now, I tell you, when I went to law school back in the 40s, thank you for laughing. It hurts my feelings. When I went to law school, I did real good in two subjects. First one was answer every question for client. It depends. So then you already went out on land. You were first out to shoot. Yes. Answer every question. Try to answer every question it depends when you're talking about legal stuff. In the second class, I did really well in the middle. So is harassment illegal? Is hostile work environment illegal? The answer is no, it's not.
That's crazy.
Illegal. Because that tricks you. It's a trick question. It's only illegal if it's a protected group involved. If you harass someone because of their race, it's illegal. Violates Title VII, federal statute, or the Tennessee Human Rights Act. If you harass someone because they're 70, violates the Age Discrimination Act. It's illegal. If there's no protected group, it is not a violation of Title VII or any of the federal workplace statutes or the state statutes. You with me there?
So you can harass somebody for their urban.
Well, now there's a catch.
It depends.
It depends. Very good. You're learning already. All of y'all have policies against harassment, right?
Correct.
Against horseplay, harassment, all that stuff. So you still get fired. It may not be illegal. If you harass someone because they park their hair on the left side instead of the right side, that's not a violation of the workplace discrimination statutes. But you're still going to get fired because you violated your company's no harassment rule, right? Same with hostile work environment. A hostile work environment is not illegal unless it's based on some protected group. Race, gender, age, disability, etc. Y'all with me on that? Have you learned your lesson about lawyer questions? Now, I want to talk for a second about stereotypes, because stereotypes is a big thing. All right, what's your name?
Tanya.
Tanya?
Mm-hmm.
Okay. Are stereotypes illegal?
Depends.
Very good. Let's a little hand for Tanya here. I think you kind of figured this thing out. Stereotypes, I mean, a lot of people think stereotypes are illegal, and they're not. Everybody in this room has stereotypes, I promise you. But if you have stereotypes based on a protected group, race, gender, age, and stuff, when you apply that in the workplace, then it becomes illegal. Just like harassment and hostile work environment. Okay? So let's talk about stereotypes for a second. I think we all have a stereotype, including me. Anybody here ever been a welder? No welders in the room? You know welders?
Oh yeah.
Are you married to one?
Was.
That answers the question.
Yep.
Welders, I have a lot of clients that have welders, fabrication jobs. And man, that is the worst job in the world. It
They're
is
whiny
nasty.
babies, too.
And what?
They're whiny babies.
They're white babies, but golly, you can't have walls because you have toxic fumes, so it's like open to the environment. So in the winter you freeze, in the summer you just drip sweat. You get that heavy steel thing on and the protective clothing, the big clothes. You just sit there and drip sweat. And then when you come home, want to sit down for dinner, your wife says, don't get me on my dinner table until you've been in that shower 45 minutes scrubbing up. Get all that stuff out from under your fingers. It's a nasty, dirty job. Now here's my stereotype. Most women don't want to be welders. Would you agree?
Yes.
I think we probably all agree on that. Most women do not want to be welders. Except for my daughter. That's my daughter Betsy. And that's her in her welding gear. She's actually welding an owl right here that is now on our back deck. She finally finished it. She loves to weld. She took welding at UT, Knoxville in the day. Took more welding classes. She has her own welding gear. At the moment she doesn't have any gear, but when she gets settled somewhere, she's, I gotta tell you, she's not just a welder, she's also a prosecutor. She's a criminal prosecutor. So she was 4.5 years under Amy Wyatt here, and then just got back from Saipan, where she was a prosecutor for 2 years. She mainly prosecuted child sexual molesters. Not a fun job. But she loves to weld. And if someday she decided she wanted to be a welder in her life, and she goes to a welding shop to apply for work, and some guy says, well, now, I tell you what, honey, that would be his first mistake, by the way. I tell you what, this is a nasty, dirty job. Most women don't want to be welders. So I think we got a secretary opening up front. Why don't you go up front and check on that list? Now that would make me mad. Because she might be that 1 in 100 females that really wants to be a welder. And because she's female, she didn't get a chance. That's illegal stereotype. Because it's based on a protected group. Anybody need a welder? Right now she's unemployed. She's looking for prosecutor jobs and stuff.
She's certified?
No, because she's never actually worked as a welder. She does it as a hobby, and she makes the big stuff. She can run a video. She's pretty good at it.
She's probably you certified then.
Yeah, she probably should. Are you going to hire her if she's certified? Can I tell her?
I'll probably be.
Smith and Nephew.
I'll probably be done, but I'm speed certified. I hope I better make.
Okay, so now we've talked about that. I want to talk, we've also talked about this, so I don't need to spend any more time on that. We talked about that consent is not a defense. I'm going to come back to that a little bit later, but try and keep that in mind as we go through this, that simply because the accused perpetrator says that she consented, that's not a defense to a sexual harassment case, just like it's not a defense to a criminal rape case. The same rules apply as far as that. So we want to be really careful of that. Today I'm only going to be talking about sexual harassment by supervisors and managers, not peer-to-peer sexual harassment, because it's a different standard. Maybe I should tell you the standard for peer-to-peer, like coworker to coworker sexual harassment. It's different because there's no authority involved. There's no managerial authority. The coworker simply say, get out of my face. They probably will, but it's different when there's someone with authority. But the standard for peer-to-peer is if the company knows about the sexual harassment, it's got to do something about it. If it doesn't, the company's liable. That's a good standard. It simply means for a coworker, if a coworker comes to Tracy and says, my coworker is sexually harassing me, you have to do something about it, and you obviously would. And if you do something about it, the company's not going to be liable. That's a great standard. That doesn't apply for supervisor sexual harassment. Doesn't apply for supervisor sexual. It's a different standard. And I want to talk a little bit about that so everybody can understand it. So I'm going to jump ahead a couple slides here and come to the end of this little section and just kind of tell you what it's all about. That's the standard for supervisor sexual harassment. Don't worry about it. We're going to go over it a little bit. You know what I forgot to do is we were supposed to make handouts for this, and I guess we didn't do it. I'll print them out and work. Anybody who wants a copy of it, I can email it. Email your PowerPoint to you. So I apologize. I just completely forgot there. The last time we did this, we had printouts. I just looked around and saw y'all didn't have them. Okay. So let's talk about these standards a little bit and why it's different. Because these two cases that set the standard were Supreme Court cases in 1991, and they set the standard for supervised sexual harassment. The Supreme Court, U.S. Supreme Court, said sexual harassment by managers, by supervisors, is the most egregious form of workplace harassment and discrimination. It's the worst thing there is. And I want to talk about why that is, why the Supreme Court said it is, and why they came up with this really tough standard, which basically says you're liable. We're going to go through that a little bit, but it's different from that peer-to-peer. Tracy, you can't get the company out of liability just by doing what you did on peer-to-peer, by going out and doing something about it. The company is strict liability in certain circumstances. I don't want to talk about that, but only if the harassment is by a supervisor or manager, someone with managerial authority. That's where this really, really tough standard applies. So,
Jeff?
Yeah.
Do people argue that one?
In the Supreme Court cases,
No, I'm talking about you saying they have to be of a manager position.
do they argue they're not a supervisor or not a manager?
Yeah, no, they argue that they are, even though the company may say, well, they're really not.
Yeah, I mean, that's fairly frequent, but,
Because there's always the unspoken hierarchy.
yeah, if the person appears to have managerial authority, even if he's not called a supervisor, this standard's going to apply. So, if you want people, if you have people, for example, who are salaried, non-exempt, they're hourly, you just pay them a salary for any number of reasons, that's fine. But you got to be careful you hold them to the line so that they're not treated as supervisors, given some sort of authority over work beyond just directing operations. That's where management relaxes sometimes, lets the standards slip, and then people who didn't intend to be deemed as supervisors get deemed supervisors by the courts. That's tough. So why is it that it's treated differently when there's a manager involved? Well, I remember about 20 years ago, we had a female attorney in our office. No, it wasn't that long, about 12 years ago. Female attorney in our office. One day she came in crying. And so I went over and said, "Gosh, what's wrong?" And she said, "Well, you know, the cop that comes to our building lobby, you like to be a cop coming to your building, checking in. You like him there. You like the presence." She said, "Well, that cop has been stalking me. He followed me to my apartment. He knows where I live. He's driven to my apartment. He parked next to me in Kroger's the other day and started talking to me. He follows me." She said, "I was out jogging the other day, this morning, and he saw me, and he pulled his squad car up on the sidewalk, blocked my path, and he gets out and starts talking about my legs." Now, when she told me that story, I got furious, like really, really, really furious. I did not count to 10, I really I knew that. What I did is I called the precinct captain. I said, "Captain," I told him what happened. And I said, "Now here's what I'm going to do, Captain. The next time I see that cop in our building, I'm going to walk up to him and I'm going to slug him in his nuts as hard as I can." It's not good HR. I'm going to slug him in his nuts. I said, "But there's a problem with that, Captain, because he's got a gun. If I slug him in the nose, he's liable to shoot me. Then, Captain, you got a problem because you're going to be explaining to your higher-ups why your officer shot an officer at the court, which is what I am as a lawyer." He said, "All right, Weintraub, I get it. You'll never see me." And I did. Now, why did I get so mad? Why did I get so furious? What do you think?
First of all, he was security.
Security, okay.
He's a police officer.
Well, did I get mad because I got a daughter?
See, that's
Would it make me mad? Yeah, it would make me mad if, thinking about my daughter But I didn't just get mad, I get furious. Why did I get furious?
She took advantage of it.
He took advantage, yeah. How?
Being presumptuous, following her home.
Presumptuous, but why did I get so mad?
She didn't ask for it.
She didn't ask for it. All true. Everything else is true. You know why child sexual molesters are successful in what they do? They're not the homeless guy you see walking down the street at Iraq. They're people who look like us. They're nicely dressed. They're pastors, assistant pastors in churches, they're school teachers, they're scout leaders. They build trust. They have authority over these kids. And they use that authority, they manipulate that authority to take slowly, gradually, to manipulate that trust and take advantage of that child. I do child sexual predator investigations, so I know how it works. So why did I get so mad in this situation with our female attorney?
Violated the trust.
Violated the trust in that the cop is an authority figure. That cop has a black uniform, big band right here. He's got a gun at his waist. He's got a big gold badge. He's got squad car, Memphis Police Department on the side. These are symbols of authority. The question is, how does the female employee say no against authority? Now, I need a volunteer. Thank you, Tony. Now, you ever done any professional acting?
No.
This your first time?
Absolutely.
Okay. So,
That mean
we're
you're
gonna
paying?
do.
Does that mean you're paying?
Thank you.
Forget.
We'll give you a day in this class.
There you go.
You and I are gonna do a little role play, okay? Now, I'm gonna get closer to the touch. You okay with that? All right. So, I'm Tanya's supervisor. She's my hourly employee. I have authority over her, okay? Now, I want you to notice one thing first of all. I'm a big guy. She's smaller than me, which is not always, but generally true. Guys generally are physically bigger. Not always, but generally bigger. And I'm bigger than her, okay? So I'm her boss. Now, Tanya, who are you? 1, 2, 3. Now, what am I doing?
Don't put your finger on her face.
Power over.
No.
What did I do? Are you okay now?
Oh, yeah.
All right, good. Yeah, just fine.
I have $3, so it's like,
Built in.
yes.
You'd be surprised. Most times when I do that, the ladies just sit there kind of like that.
Oh.
Don't push back. Maybe they think it's just part of the drama. But what did I do?
You try to intimidate.
Try to intimidate you, but maybe I won't even try it. But I'm bigger than you, number one.
And you're my boss. So
And I'm your
say
boss. How does she say no? How does she say, get out of my face? Which she finally did, which is good. We like that. But most of the time they don't.
Yeah.
Let me explain something. Tanya, all of y'all have been raised since birth to respect authority.
Yes.
You're taught as a little kid, do what your teacher tells you to do. Do what the policeman tells you to do. Do what the judge does. What's the union credo? Obey now, grieve later. Right? We're all taught from birth to respect and obey authority. How is it that when we got the classic pattern, a larger male supervisor, a smaller female who's been taught from birth to obey and respect authority, how can we look at her and expect her to say, no, get out of my face? Which Tanya did. We like that. But I'll be honest with you, most don't.
You were correct.
Most don't. I'm sure you've taught your daughters to push back. But most don't learn that. It's a manipulation of authority. And that's why I got so mad, because that cop knew that our attorney, our female attorney, had been raised since birth to respect authority. He knew he could count on that. He manipulated that authority to take advantage of her trial. Does that make sense? That's how sexual harassment by supervisors work. And that's why the Supreme Court said this is the most egregious form of workplace discrimination and harassment. And that's why they came up with this standard, which is really tough. So I know it's a lot of legal mumbo jumbo. Let me just go over it quickly. To be actionable, supervisor sexual harassment. First, the sexual harassment has to be severe and pervasive. What that means is that a supervisor telling one dirty joke is not going to be actionable, no lawsuit. What about a series of dirty jokes? Maybe one touch on the arm, not actionable. What about multiple touches on the arm? Maybe. Are you a touchy-feely supervisor? Not a good idea. I'm just telling you that. There was a day 30 years ago, but if you're touchy-feely and you don't mean anything sexual, here's the point. If someone does get fired for whatever reason and wants to sue for sexual harassment, she's not going to fabricate a story about sexual harassment. She's going to take what she's got there. Because the touchy-feely supervisor is the one that she'll remember. Those two supervisors that tells dirty jokes. Out of 400, 500 of these sexual harassment cases I've had over the last 30 plus years, you know how many I've seen that were totally fabricated? 5. 5 out of almost 500 were fabricated. The rest were basically true. Now, I will tell you that often they're exaggerated. Claims are exaggerated. Often they're embellished. But they're rarely fabricated. They don't need to fabricate. They just pick the person who's been telling the dirty jokes, who's been touchy-feely and all that stuff, and they point the finger at him. I gotta tell you, they don't need to fabricate it because every workplace in America has some guy messing with the ladies. Can I get an amen on that? So they don't need to fabricate, and they don't. They point the finger at the guy that's been telling the jokes and being touchy-feely. And again, maybe he didn't think it in sexual terms. But when you do it, you become the target. Do you want to be the target? So, you know, we've got this thing, this horrible rule that I'm going to go over with you, what the standard is. But it's so simple. This is, as bad as this area is, most Supreme Court said this is the worst area of workplace harassment, it's the easiest to prevent. And I'm going to tell you how, before we go into the standard, just so you won't get too depressed. Now, I'm going to tell you the standard, but one day I'm going to get sued for this. I'm going to tell you, even though it's going to have digitally, probably social media all around the world. Anybody ever worked with Nike? Have any dealings with Nike? You got some Nike shoes?
No, but yeah,
What's Nike's slogan?
just do it.
Just do it. So I call it Ekin, spelled Nike backwards. Just call it Ekin. Just want to get sued. And what would that slogan be? You flip it. How about just don't do it? It's so simple. If a supervisor hears the employees telling dirty jokes and walks over and says, hey, I got this joke on. Oh, what did that lawyer say? Okay, never mind. You walk away from it. Maybe tell the employees to do that work too. You just don't do it. Then you don't have to worry about this formula up here, the standard, this horrible standard. So let's talk about the standard, and I'm not going to spend a lot of time on it, just so you know that this is virtually strict liability, which means the company's always liable, or mostly liable. So assuming we have severe and pervasive sexual harassment, and as I told you, if it's alleged, it usually happened. Not always, I don't want to get too cynical with it, but usually the allegations have something to them, although they're typically exaggerated too. But assuming we have sexual harassment by a supervisor plus a tangible employment action, what is that? Well, that's something bad that happens to the employee, like let's just say they get fired. So if they get fired because of sexual harassment, then the company is liable. And there is no defense. Now, Tracy's about to get mad because she says, wait a second, Jeff, we have a sexual harassment policy. I enforce it. I encourage employees to complain. And if it's valid, if there's merit to it, a prompt remedial action. Tracy, you see that in that first standard up there? Is there a defense up here for that? There's not. At that first level of this standard, there's no defense that, hey, we have policy in place. And we took prompt remedial action, we investigated, we encouraged employees, there's no defense for that. The Supreme Court decided this area of manager sexual harassment is so egregious that we're going to make somebody pay, and that has to be the employer. So if there's supervisor sexual harassment, which as I told you, it's alleged, usually something happened, and if it results in a termination or discipline or something, then the company is liable. That's why these attorneys' letters that y'all get in the mail, Dan Norwood and Donna Nadi and other really good plaintiffs' attorneys around town, are going to say, my client Sally's, y'all just fired her a month ago. She was sexually harassed by her supervisor. Y'all can investigate, you'll see it's true. And she was terminated because of that. So y'all now owe us $3 million. But Kmart Blue Light Special, today and today only, we'll let you off the hook, give you a release for $500,000 cashier's check by 5 p.m. That's kind of what these letters say. They're all kind of the same format. They're all basically accurate. So what do we do about that? I mean, well, some people say, well, wait a second. You said the sexual harassment has to joke that.
I have a question. So do you typically, of these 500 cases,
Yeah, we pay the $500,000 every time.
the person that got harassed has been fired, but
It's pretty typical.
and it somehow relates back to
Pretty
the
typical.
situation.
I mean, that's usually the person's been terminated because nobody likes to make waves when you're an employee. Once they get terminated for something, there's no reason to be loyal to the company anymore.
So they weren't making waves. They didn't get fired because they started making waves. This is not retaliation.
This is not retaliation.
Okay.
This is just sexual harassment by a man.
It was just their day to get fired because maybe they really were a bad employee.
Maybe they really were. And that's a good lead in to this point. Because I get asked a lot, well, wait a second, we have legitimate reason to terminate her. So, okay, maybe she was sexually harassed, but the sexual harassment didn't result in her termination. Well, why'd you fire her? We fired her under a no-fault absenteeism policy. She had 21 points. Everybody that has 21 points gets fired at our company. Everybody. Okay. So we say that she wasn't fired for the sexual harassment, even if that. All right, fine. When did her absenteeism problem start? I guess it was about 6 months ago she started having a lot of absences. When did she say the sexual harassment started? Well, about 6 months ago. Right. So maybe what happened is the sexual harassment started. And she hated it. She didn't know how to say no because she was raised to obey. So she instead would go in the bathroom and just cry. And then one day she tells her husband at home what's going on. Now the husband wants to come and beat up the supervisor. She says, no, you can't do that. I'll get fired. You'll get arrested. So now her home life is miserable. She hates coming to work. And yeah, she started having a lot of absences because of the sexual harassment. So even though it's 21 points under the no-fault absenteeism policy, it arose from the sexual harassment by the supervisor. Does that make sense? So that's our problem. It's pretty hard to disprove some of this stuff, especially when you consider, as we talked about earlier, that consent is not a defense to these cases. Only unwelcomeness is, not consent. But there's another level. It's not the end of the world totally. There's another level. What if there's no tangible employment action? What if it's a hostile work environment and nobody gets fired or demoted or disciplined or anything? It's just a hostile work environment by the supervisor that created. Got dirty pictures floating around. What's that? Snap-doodle calendars. You know you have in your workplaces somewhere. Snappy, whatever it's called. And but nobody's gotten fired. So there's no tangible employment action. There's just that. Then you possibly have an affirmative defense if you get two things. One, you get the affirmative defense, and if there's no termination or anything. If you got the good faith stuff, what is that? As Tracy would say, her policy against sexual harassment, the no retaliation policy. She encourages employees to complain about sexual harassment. If they do complain, she investigates in good faith. And if the investigation shows there's merit to the allegation, then she takes prompt remedial action, maybe a termination or discipline or something of the perpetrator. Now, every company has that today. So everybody meets that one. Then there's this big and, because you have to have the second one too. The second one is that the plaintiff has to have failed to avail. What does that mean? It means that the victim of the sexual harassment failed to complain about it. Here she has a policy, and she expects employees to complain. She tells them to complain if they're harassed, and this person didn't do so. In that case, you get a defense, potential defense. There's only one problem with this. just really screws the whole thing up for them. It's that word "and." You have to have both of these things. Let me ask you this. What if there's nobody's been terminated, it's just hostile work environment, dirty pictures and dirty jokes and stuff floating around, sexually aggressive atmosphere. The company has the policy and the plaintiff failed to complain about it. Then we can get the case dismissed. Well, what if she does complain? What if she does exactly what Tracy's policy says to do, to complain about sexual harassment? If she does complain, you lose your defense because the "and" have got both. What I'm saying, Tracy, you're not going to like this, is that in this situation, your sexual harassment policy is worthless unless it's not used.
Well, and also, you kind of lost the good faith stuff there too, hadn't you? Because shouldn't you, as the company, gone and told the person to take down their calendars or the pictures or
Yeah, that's true too.
stop telling jokes also?
That's true too. But there might be stuff you don't know about. Behind the scenes, you don't know about. So, I mean, that's all true, and that's a good point. But at the end of the day, if the plaintiff does complain, you lose the value of your policy. There's no defense. You know what the answer is to that? Because this stuff really happens. If the plaintiff complains, you lose your defense. Now you're back up here where you're liable. The only way you can get this defense is if the plaintiff doesn't use your policy. So HR people look at that and say, well, dang, our policy is worthless. In that scenario, it kind of is. But there is a solution, Tracy. One solution. If she does, well, yeah, she does that. If she does complain, and Tracy, you run out there and fix the problem promptly, then guess what? It never is severe and pervasive. Because you caught it. Remember we said one touch, one dirty joke, not actionable? So if you catch it on the first complaint and deal with it, then it's not going to be severe and pervasive sexual harassment. And we don't even have to worry about it.
So even-
a case where the plaintiff didn't complain, but she told her boyfriend, who was in college states away, he called us and told us about it, and we were able to take care of it. And
That's
so
right.
we were.
That's a complaint. I mean, it didn't come from her.
Yeah, it didn't come from her, but she told him, and so we still.
That gave the opportunity.
Yeah, we could find.
So you took care of it
Yeah, we did.
and prevented it from being severe and pervasive. But you didn't get that defense, which essentially got you.
So even if it's been going on a long time and it's multiple layers and it is pervasive in the company, as soon as the complaint's been, a long time coming, if you deal with it when the complaint comes, you still prevent the severe and pervasive?
I mean, if it's been going on a long time?
Yeah, but no one's ever complained about it.
Well,
You took action as soon
Yeah,
as
you took
somebody.
action as soon as you really knew about it.
yeah. And I've had that situation many times. I had a casino case years ago in Tunica where the male vice president was sexually harassing a female director, and she never complained about it. It was like a year. It was really bad, gross, graphic stuff. And she never complained. Then she got terminated in a reduction of force. It really had nothing to do with sexual harassment. But again, that's the point they sued. No more loyalty to the company. So she sues for millions of bucks. And we investigated, did all the right things. It was a deposition. And I asked her, how long has this been going on? She said, oh, a year. And I said, well, why didn't you complain? She said, I should have. Boom, I won the case. It's that simple. But the problem is, if they do complain.
So she should have said it would create an
Exactly.
hostile environment. I just could not do that for fear of losing.
Yeah, now fortunately the law is kind of on the important side on that because it takes a lot to justify not complaining. About the only thing that will justify not complaining, I mean, the threat to lose a job, the courts have said, no, you still got to complain, even at the risk of losing your job. If there's a threat of physical violence for complaining, then the courts will say, yeah, there's no obligation to complain. So that's kind of the standard. I don't want to spend any more time on it. The thing to remember is that the manager standard is, the top level at least, is strict liability. It means your company's automatically liable. So let me ask y'all a question. What if we have this situation, this first one? You get that nasty letter from the plaintiff's attorney who says, you fired my client a month ago She was being sexually harassed by her manager. It resulted from the sexual harassment. Please send me that $500,000 certified check. How do we get out of that? It's strict liability. And basically what the lawyer says is true. You owe the money. Is there a way around it? Yes, there is. It's a good one. And I've got to say, I sort of invented this one many years ago, and now everybody does it, but they figured it out on their own too eventually. But here's the answer. A, you investigate. Now, non-employment attorneys don't understand this. They don't understand, the old attorney thing is circle the wagons. Don't do anything further. Fight the lawsuit. That's not the way you do it. Title VII says you as an employer have an obligation to investigate allegations of sexual harassment. That obligation doesn't stop simply because a lawsuit's been filed for $1 million. So the first thing we're going to do is investigate. And we'll probably figure out, in your investigation, Tracy, you'll probably figure out the sexual harassment did happen at some level. It may not be quite as much as the plaintiff alleges, but there's probably something to it. There usually is. So once you've made that determination, you realize this person shouldn't have been fired. Maybe she had the points, because of sexual harassment, so she never should have been fired. So guess what you're going to do? Offer her job back with full back pay. I mean, no big deal. It's just a month. And, well, you can fire the perpetrator. It's sort of a knee-jerk there because you've determined there's merit to the allegation. So this is a supervisor who knowingly violated your policy. Knowingly. How would you fire? You should. So now she has no reason not to come back to work. So if she then comes back to work with her month back pay and the perpetrator gone, guess what? There's no more tangible employment action. We pull the teeth on it. There's no termination. We're now down here. That means we have the possibility of affirmative defense. And we can win that case. Does that make sense? That's a pretty good tip, wasn't it, Tracy? Yeah. Do you think it makes good enough sense that we could get Buddy's cap there? Maybe pass around the room, everybody like to put a $2 love offering in it for the Lord. Well, I thought it was a good idea. Okay, so that's the standard, and I don't want to spend any more time on that. But it's a tough standard. Now, the good news is that petty slights in the workplace don't constitute actual sexual harassment. Title VII, as the Supreme Court said, is not a general civility code. You can be a jerk in the workplace, and that doesn't violate Title VII, as long as you're what we call an equal opportunity jerk. If you're abusive to both males and females, that probably won't violate Title VII. Because remember, it has to be a protected group. If you were targeting just females or just males, then it would violate Title VII. But if you're equally abusive to everybody, probably no violation of the employment statutes. But there's still a problem. Because if you're an abuser and a jerk, you're going to be very unpopular. And when someone wants to sue, they're going to try and find a way to sue you. So it's true, equal opportunity jerk is a defense, but there's a lot of risk with it too. So I wouldn't do it. Okay. Judge Casey down in Texas. Anybody ever heard of him? Probably not. I was asking. Russ Casey was a judge, a magistrate or something in some town in Texas. I don't remember where. And he had a female clerk who had been with him like 15, 20 years. And he let her go, and she sued for sexual harassment. She alleged that Judge Casey, a couple times a week, was requiring her to come into his chambers and give him oral sex. He denied it. She sued. And he kept up his denial. I didn't do it, I didn't do it, I didn't do it. Until the day she brought into the courtroom one of his black robes she had kept and had his semen on. 2 days later, the case settled. And she got a lot of money. And Judge Casey is no longer a judge. You know who those folks are? These three ladies in the front row are three plaintiffs in a sexual harassment suit that EEOC, and that's their attorneys in the background, EEOC's attorneys. Some of you may have Kenneth Anderson, who's no longer with them, good guy. But they sued for sexual harassment in Mid-America Specialties, a warehouse operation in Memphis. Anybody know them? I'm not even sure it's still around. They were one time. The jury awarded them $1.5 million for sexual harassment. And the EEOC put this picture into the commercial guild a couple days later. You know what's interesting about this? Is that like 2 years before, Mid-America Specialties was voted by Memphis Magazine best place to work in Memphis. 2 years later, they're paying $1.5 million. Crazy. Now, we got your buddy Harvey up there. Who are the others? You see Matt? There's Matt Lauer. He's gone. He got fired for sexual harassment. Who else you see?
Senator Brandon or whatever.
Al. Al's gone. Who else? Oh, come on.
I'll recognize.
That's Roy.
Oh.
Roy Moore. Who lost his election in Alabama. Now this is interesting because when you think about it, the allegations against Al, there weren't a lot of them. There wasn't a bad picture of that. The allegations against our president are far worse. By far more many people. Anybody think President Trump's going to resign like Al did?
No.
I don't think that's going to happen. But and it's happened more and more and more. Who lost their jobs a couple of weeks ago? 5 commentators and analysts for ESPN and the NFL Network were fired for sexual harassment. You remember this? Now, 2 of them, the names I really remember. One of them was Marshall Falk, running back, I believe, great running back. The other one was a former Eagles quarterback. Who was it? Donovan McNabb. Donovan McNabb was fired. Happens to everybody. And then I think I mentioned earlier, the president of Ford North America stepped down yesterday or the day before. The president of Ford North America. It's amazing. The Me Too movement is making it happen. People are now, stepping out and saying what happened. And this is good. We need to address this problem. It hasn't been addressing this problem until our buddy Harvey. And now we have Harvey to thank that people are coming out of the woodworks, the victims, and saying, hey, enough is enough. We're tired of being scared to complain and being mocked and laughed at when we complain. This is a problem that we can deal with, and we can deal with it in our own workplaces. That's what this training is about. So, now, let's talk for a minute about sexual orientation. This is interesting. Now, you may be surprised by some of the stuff I'm going to tell you. Maybe not, but we'll see. But there's a lot of misunderstanding about sexual orientation. First, we got to talk back again about Title VII. Title VII, remember the 1964 Civil Rights Act has the 5 protected groups. One of them is sex or gender, right? And here's what you got to remember from this. The sex that's referred to in Title VII, protected group, refers to biological sex, not sexual preference. Biological sex means the state of being a male or the state of being female. If the actions that happen, you're investigating something in your company, if you can determine that the actions that were done to the complainant were done because of sex, and that's the phrase remember, because of sex, referring to biological sex, then it's a violation of the statute. If it wasn't done because of biological sex, it's not a violation of the statute. That's the way it's been in this country for 60 or 70 years. That's the way Congress set it up. And until about a year and a half ago, no federal court of appeals had ever said otherwise. Now there's one, the 7th Circuit, that has said otherwise. So that will probably go up to the Supreme Court. My prediction is that that decision will fall because it is crystal clear that sex under Title VII refers to biological sex. So let's talk about first heterosexual sexual harassment. You got a male supervisor and a female victim. Could be the other way around too, obviously. Or it could be male and male or female on this. All going to be violation. Heterosexual supervisor, male, is hitting on a female hourly employee. Why? He's doing it because she's a female. In the eyes of the law, he's harassing her because she's female. Does that violate Title VII? Yes. He's doing it to her because of her status of being a female. So it's because of sex, biological sex, and therefore it violates Title VII. Okay? Everybody with me on this so far? Okay. If it's because of biological sex, then it's a violation. If it's not, then it's not a violation of Title VII. So let's keep that in mind as we go through all the possibilities here. And, you know, this slide, I probably need to revise this slide because I've been saying it for years. It's been true until about a year and a half ago. But now, like I said, there's this 7th Circuit Court of Appeals. Doesn't affect us. We're the 6th Circuit in Tennessee. That said that sexual preference is covered by the sex discrimination provisions in Title VII. And in my opinion, it's completely wrong. But my prediction is when this goes to Supreme Court, they will decide that this is wrong. This is a Hively case. If you ever want to keep up with it on Google, H-I-V-L-E-Y, I believe it'll be overturned. No other court of appeals in 60 years has reached that conclusion. They've all concluded that the sex in Title VII refers to biological sex, the state of being a male or a female. So, having said that, let's talk about the possibilities here. The possibilities are this. There's 4 possibilities. There's a little board here. Let me use this a second. I did this once and I picked up the wrong marker. So now I check. Whiteboard marker.
Not Sharpie.
Not a Sharpie, I guess that's what I use. There's 4 possibilities. And I want to go through this so you can analyze in your own companies whether you have an actionable, potential actionable cause of action going on that you need to be really careful about. So the first possibility is we have a gay supervisor who is sexually harassing a gay employee. The question is that actionable? Is it unlawful under statute? Can he sue over that? Here's our victim. These are both male, or they could be both female, but it's same sex, okay? So he's going after him. Why? Why is the gay supervisor sexually harassing the gay employee? Remember our heterosexual. The heterosexual supervisor, male supervisor, sexually harassing a female is doing it because she's a female, and that's what makes it illegal. So why is he going after him? Because he's a male. He's gay, so he's going after him because he's a male. So is this actionable? Yeah. Yeah, that's actionable. It's against the law. He can sue. So if you've got that situation, that's actionable. You need to be on the lookout for it. Now, I got to explain something, though. Is it actionable because the victim is gay? No. So listen to this part. This is the part that a lot of people don't get. Homosexuality is not a protected group under the federal statutes. Homosexuality is not a protected group, except in the 7th Circuit, because they've now ruled it is, but no other federal court of appeals has so ruled. And the 6th Circuit specifically said homosexuality is not a protected group. Remember, Congress said the sex in Title VII is protected is biological sex, not sexual preference. So homosexuals as a group are not protected because of their homosexuality. So what about this? What if the gay supervisor is sexually harassing a straight employee, male on male or female on female? Why? Why is that actionable? He's doing it to him. Why? Because he's a man. Because he's a male. So that is unlawful sexual harassment. Doesn't matter whether the victim is straight or gay. The point is the supervisor is gay, male supervisor, going after a male employee. He's doing it to him because of biological sex, being a male. So yes, that is actionable. Now it gets tougher now. Let's say we got a straight supervisor who is harassing a gay employee. Is that actionable? Why not? Well, homosexuals we know are not protected because of their homosexuality. Why is he going after him? He's straight, the supervisor. Why is he harassing this guy? Because what? Yeah, so why is this straight supervisor going after him? He doesn't like gay people. Yeah. It's called gay bashing. Is that illegal under the federal employment statutes? No. Remember, homosexuals are not a protected category under the federal employment statutes. So this is gay bashing. It is not illegal under Title VII. Now, let's stop a moment and remember that you have policies at your companies that this may well violate. You may have a policy that says no harassment in the workplace. That would violate that policy, so you may be firing a supervisor. But we're not really talking about company policies here today. We're talking about the law. And so under Title VII, sexual discrimination provision, this is not unlawful. It's gay bashing, but it's not unlawful. You can prohibit it by policy, but it's not a violation of the federal statutes. Now, at this point, I should say, around the country, there are a number of states that have passed laws protecting homosexuals, like the state of Washington and others. Tennessee has not. Mississippi has not. Arkansas has not. However, some cities have enacted ordinance protecting on the basis of sexual orientation. Like one city I can think of is called Memphis, Tennessee. In Memphis, there's a city ordinance that city employees cannot be discriminated against or harassed because of their sexual orientation. It's not the federal statutes, Title VII, but it's a city ordinance. Same for Knoxville, same for Nashville. Is it the same for Chattanooga? No, interestingly. Chattanooga passed an ordinance barring sexual orientation discrimination, but it was subject to a voter referendum, and the voters voted it down. So in Chattanooga, city employees can be harassed on the basis of their sexual orientation. But again, we're not really talking about that. Gay bashing doesn't violate Title VII. Now, this is going to get interesting. Straight supervisor harassing a straight employee. Does that violate Title VII? When I worked at Campbell 66 on the loading dock, we had a guy, we had a supervisor there, and he didn't like, on the loading dock, it's called, you gotta have hustle if you want to not get fired. So I usually hustle. But this supervisor, he's kind of a jerk. And if he saw you not hustling, standing on a broom or something, he would come up behind you, including me, sneak up behind me, and reach out and slug me on the arm and then run off cackling and laughing. Now, I should explain to you, this is what guys do. Okay? So, when that guy slugged me on the arm and ran off laughing, could I have sued Campbell 66 for sexual harassment under Title VII?
No.
That wasn't sexual. Yeah. That was just straight back.
Sexual harassment isn't always sexual. Sometimes it's other stuff in there. Could I have sued for sexual harassment? Why was he doing it to me? Was he doing it because I was a male? No. He was doing it because he was a jerk, or he didn't like me, or he was stupid. But it wasn't because I was a male. So it can't be actionable sexual harassment, right? Thank you, Tanya. Good answer. Yes, it might depend. And
It's still unwelcome.
it's unwelcome, but that doesn't matter. It's like harassment. It's not illegal unless it's a protected group. He wasn't doing it to me because I'm a male. So my view is that that's not actionable sexual harassment. However, you guys are going to say however. However, 1986, there was a case went to the Supreme Court, came out of Texas, trial court. And this was a case in the Gulf of Mexico, an oil rig. And what happened was there was a male supervisor, and then you got a male employee. The supervisor didn't like this guy. So one day the supervisor got all of the coworkers out and said, all right, hold this guy, grab him, hold him down, throw him down on the deck. It was on the deck of the board. And so they did. So the supervisor comes over, takes out his penis and lays it across the guy's neck.
Oh, hell no.
Then he takes a bar of soap and sticks it in up the guy's anus. Actionable sexual harassment, I'm trying to say.
Yeah.
What do you think?
When body parts are involved, you would think it's automatic.
Why was the supervisor doing to him what he was doing? Was it because he was a male, or was it something else? There's no evidence in the case that the supervisor did what he did to this guy because he was a male. In this case, went up to the U.S. Supreme Court in the mid-'80s. I read the facts, and I bet a buddy of mine $5 that the Supreme Court would say this was not actionable sexual harassment under Title VII. Because, in my view of the facts, the supervisor wasn't doing it to this guy because he was male. He was doing it because he didn't like the guy.
Yeah.
Could have been a female that he didn't like. Could have done the same thing. There's no evidence that what he did because he was a male. So did I lose the $5 or did I win the $5? Was I right or wrong? Well, this is one of those trick questions, Tracy. The Supreme Court didn't decide it. They sent it back to the Texas trial court. It's called remanding. They sent it back to Texas trial court because they said there wasn't enough facts in the case to tell. To tell what? Well, I think to tell whether the guy had a motive to do this because the victim was a male. They couldn't tell from the facts, so they sent it back down to the Texas trial court for trial. Whereupon the parties settled the case. To this day, we don't know whether that's actionable sexual harassment. So let me tell you what I tell clients about this fuzzy area. First, if I tell the story about me on the loading dock, no, I don't think that's actionable sexual harassment. Where the supervisor slowed everything off. He didn't do it to me because I'm a male. He just did it because he was a jerk. I didn't like him. Not because I'm a male. Not actionable sexual harassment. So what the supervisor did on the oil rig, to me, it was not done because the victim was a male. Just the supervisor didn't like it. But I don't know for sure because there's not enough facts in the case. They didn't have enough facts in the trial court below. What if the facts show that the supervisor was gay?
Right. Yeah, that's
And maybe what he was doing was because of sex.
Yeah.
But we don't know because the case settled. We got sent back for trial down in the Texas trial court. To this day, what I tell clients is this. I say, if it's horseplay, harassment, stuff like that, normally not actionable under Title VII because it's not being done to the victim because he's a male or because she's a female. It's being done for some other reason, like the supervisor's a jerk or something. But if it involves genitalia, who knows? So that's where we are today. We don't know an answer to that question yet. I still say that as gross as that was, I don't believe from the facts that I know of, the supervisor didn't appear to be gay. So I don't think he was doing it to him because he was male. I think it really was because the supervisor was a jerk. But I don't know. I could be wrong about that. Okay. That is about it. So are there any questions about sexual harassment? Just remember the training is really perfect training for y'all because y'all are supervisors. And y'all are HR and managers and VPs and stuff like that. It's good for y'all too. And usually who I speak to is HR people and owners and so forth. But ABC is trying to offer this as training for supervisors too. So I think we're going to repeat it maybe a couple of times. And if you want to send your supervisors to the training, we're not charging for it. If I did it for your company, personally, I would charge you. It's not really expensive. I charge for a couple hours a time. But ABC is doing this as a service to all the contractors, all the members. So if the next time we do it, if we fill the room with supervisors, then you get all your supervisor training, which is going to protect the company. It's all that good faith stuff you saw on that chart. It protects the company, and you won't have the cost of doing it yourself, which is a pretty sweet deal. So I think we're going to do it again, maybe in a month. we're gonna try and market it a little bit more so everybody knows it's happening, and we'll have another opportunity. But be sure, especially you guys, sign that you attended so your employer can prove that you've had the sexual harassment training. That protects the company. It protects the company in the event of a sexual harassment lawsuit. One case I had a few years ago, they'd never done any sexual harassment training. They didn't even have the proper policies. And, you know, I had to settle the case because I knew we were going to lose in front of any judge. Because we already had strikes 1 and 2 against us. We didn't have the right policies, and we didn't have the training. You got the training, you meet that burden, and that's step number 1 and 2 in winning these cases. So, any questions? All right. Do what? Well, we got. You didn't see the video, Russ, but maybe if you come next time, this will be it. You can come for the first 30 minutes and then leave. Okay, thanks everybody.
Thank you.
I was just looking at it last night. He would have had to Walmart. He would have told us to say.
Oh, that's it.